The next little or no money down acquisition strategy is what's referred to as a mirror wraparound, or wrap. What we're going to do here is buy a property from the seller by basically giving them a note that mirrors their existing payment. Now this is similar to taking a property subject to the existing mortgage, except we're not getting title. So we're going to buy on what's known as an installment land contract, an ILC, otherwise known as a CFD, contract for deed. So an installment land contract or contract for deed is where the seller has title to the property and he's got an existing mortgage and he's going to sell to you, to the buyer, on an ILC or contract for deed. And the agreement basically says you're going to make payments on this contract for principal, interest, taxes, and insurance that mirror and match the terms on the existing underlying mortgage. So it's like you're assuming it, but you're not asking the bank for permission. And title remains in the seller's name for collateral, which makes the seller feel a little better about the deal. They're not just giving up the deed with no recourse. They're signing this agreement with you that says, basically, let's say the balance is $90,000, okay, at 4% interest, and there's 25 years left on it. So the contract says you owe the seller $90,000 with a finishing amortization of 25 years at 4%, taxes and insurance exactly what he's paying. So mirroring the payment. So you're making payments to the seller makes payments to the lender on a mirror wraparound. Now, even though the deed is in the seller's name, you're the, quote, owner for all intents and purposes, especially for tax purposes. I know it's confusing because the deed hasn't transferred yet. How could the buyer be the owner? The IRS has said this is a sale because the buyer has all the benefits and burdens of ownership, you know, principal and interest, taxes and insurance, right to live there, right to improve it. The only thing the seller's holding title for is collateral. So if the buyer defaults, the seller still has title. In some states, the seller has to foreclose. In most states, it's patently unclear. It could be an eviction, it could be some other proceeding, but you know, possession is 9/10 of the law. If the seller has the title, they feel better about it. So if you're talking to a seller who's current on his loan, unlike a subject to where the seller might be behind and doesn't care about giving the deed, then the contract for deed or a land contract on a mirror wraparound may work very well. Now, a couple of points here to protect yourself if you are the buyer in this scenario. If you make payments to the seller and he doesn't make it to his mortgage, and it's a mirror, so he's not making anything monthly, he doesn't have a lot of incentive other than, you know, protecting his credit to pay the underlying mortgage. If that doesn't get paid, mortgage forecloses, wipes out your land contract. You're in trouble. I would recommend either you making it directly to the mortgage company or having a third-party escrow servicing company. In addition, the seller signs a deed to the property. Now, the deed doesn't transfer and get recorded to the buyer. It gets placed into escrow with an attorney or title company or escrow company with instructions that when B tenders the balance of the contract, the deed gets recorded in the buyer's name, and if the buyer defaults, then the deed goes back to the seller. And that kind of protects all parties involved. And this is a great way, again, to get into a property, maybe doesn't have a lot of equity, but it has a favorable loan that you can mirror wrap with very little money down to the seller by effectively assuming his loan, but not really assuming it.